the last year, more and more practices and individual doctors have become aware about the medical legal risks that can arise from privacy breaches. I'm thinking about some very significant portal breaches, cyber attacks, and the constant issues around who we can release health information to without specific consent. We get calls at MPS on these issues every day on our advice line. Compliance with our privacy obligations is a big part of medical practice, and today we're going to talk about a new obligation under the Health Information Privacy Code, which is coming into effect very soon on the 1st of May 2026. And this relates to information practices and clinicians received from sources other than the patient themselves. So welcome to Reducing Risk, which is a series of podcasts from Medical Protection created specifically for doctors in Aotearoa, New Zealand. Reducing Risk looks at key medical legal issues in our jurisdiction, provides helpful advice and guidance on how to manage those risks. And today we're looking at the update to the Privacy Act, which comes into effect on the 1st of May this year and is memorably named IPP3A. And we are lucky to have a special guest to help us understand the changes. So I'd like to welcome back Stephanie Gregor, who's Manager of Capability and Guidance at the Privacy Commission. Welcome back, Stephanie.
Thanks, Lucy.
And we also have another return customer, Adam Holloway, the partner at our law firm, Wootton Kearney, who's going to help answer all those curly legal questions. Welcome, Adam.
Hi, Lucy.
And last but not least, we also have my colleague, Dr. Sam King, who, like me, is a medical legal advisor from Medical Protection Society and a GP. And my name is Dr. Lucy Gibbard. So I think we might start by defining our terms here. We're going to be referring to the part of the Privacy Act that clinicians work under, which is called the Health Information Privacy Code, as the HIPC. And we're going to be talking about the new update, which in full is called the Information Privacy Principle 3A, as IPP3A. So, what is IPP3A and how will it change how we treat health information? Well, look, to think about that, I think we should probably start with what the current HIPC rules 2 and 3 say, to give some context of what the changes actually are about. And it tells us why that update was needed. So, Adam, can you tell us a little bit about rules 2 and 3 and what's the background?
Yeah, absolutely. So the Privacy Act is the law, the piece of legislation we have that sets out people's privacy rights and governs this area. And at the heart of that piece of law are a set of what are called information privacy principles. But in the health space, how those information privacy principles apply specifically to health information is there's a gloss or a nuance that put on it. So instead of looking just to the information privacy principles, we turn instead to this Health Information Privacy Code. And each of the rules in that code correspond with one of the information privacy principles. So the new principle, 3A, will be represented by a rule in the code, 3A. In terms of, to set the scene, as it were, the first rule in the code and the first information privacy principle at its core says we should only collect information from someone if it's for a lawful purpose. And the second rule is that information should be collected directly from the person that it's about. So rather than going behind someone's back and collecting information, if you can, you should be asking them directly. And then the third rule is that organisations should be open about why they're collecting information and what they'll do with it. So you collect information from the person concerned, but you're also transparent that you're doing so, and you're being clear with that person about what it is you're doing and why. And what goes with that in that Rule 3 is a set of obligations to tell the person why you're collecting the information, whether it's compulsory or voluntary that they give the information to you, who's going to be receiving it, what will happen to the information if they choose to provide it, and to remind them that they have rights to access that information, to know what it is you hold about them, and to ask for its correction. And Rule 3A is really just mirroring those existing rights, but in the context where instead of collecting information directly from the individual concerned, you have collected it indirectly from somebody else. Because we know that does occur, particularly in medicine, where as a GP practice, you might receive a piece of correspondence which contains a lot of information about one of your patients. And this new information privacy principle really deals with that sort of situation and what the rights of individuals are in respect of information you've collected indirectly.
Right. So the old 3A was, we had all these obligations about when we collected it from the patient themselves, to let them know we had it, to let them have access to it, to tell them what we were going to do with it. But now the new one says, well, when we collect that information from someone else, we still have to tell the patient all those things.
That's right, yes.
Is that basically it?
Yes.
So, Steph, why was that change needed? Why was an update needed?
Yeah, I think there's a few parts to why 3A was brought in. So first of all, it was brought in through an Amendment Act to the Privacy Act more generally. So it's not just in health that is bringing in 3A. But agencies, particularly in the modern world, are just collecting so much personal information from heaps of different places, from individuals still. That's the sort of the basic headline, what people should be doing. But there's also lots of really good reasons that they are collecting it indirectly. That's already dealt with in Rule 2 or IPP2. But at the moment, there would be no way for an individual to know where information actually is held if these agencies have collected it indirectly. And so it's kind of hard for these individuals to be able to exercise their privacy rights if they don't even know where the information is in the first place. So that's one reason that it was brought in. It's just kind of reflective of how information travels in the 21st century. But also it's a really common thing overseas. We've been a bit of an outlier for not having this indirect collection notification requirement here in New Zealand. The GDPR, which is the European Union's equivalent of the Privacy Act, they just talk about notification. They don't really distinguish between direct and indirect, and it deals with both that you have to tell people. We have, as a country, I won't go into it too much, but we've got this thing called EU adequacy, where essentially the European Commission says that the privacy laws that we have here are pretty much the same as they are in the EU, which means it's really easy for people who live in the European Union, for agencies to send information to us without it being too much of a drama. And in their most recent report on our adequacy status, they said, but you do need this indirect notification requirement. So that's part of how that all happens. And the reason it's come through to the code in the way it has is that the way that codes work under the Privacy Act, if we didn't bring it through, it would just come through as it is in the Act, which doesn't have any health-specific exceptions. And I know we'll get into the exceptions in a bit, but that's why it's come through to the code in as well, to make sure that it properly applies to how the clinical setting works in practice.
So, in summary, for the clinicians and practices, we've always had an obligation to tell the patient that we collect information from them and what we do with it, although in clinical care, patients obviously know that we collect it because that's why they've come to collect information. But now we have a similar obligation to tell our patients when we collect information about them from someone other than themselves. So it's not really that different, is it? But I suppose the application of it is quite different in terms of how it works out in practice.
Yeah, and on the face of it, you can imagine that it could be an enormous job. We constantly collect information about our patients' lab results, radiology reports, outpatient letters, discharge summaries. If we had to tell our patient about each time we collect a piece of information about them, literally we would be doing that all day.
Yeah, I think the good thing is having Stephanie here and knowing that the guidance is just about to be released, is that you've looked at the practicality of what that looks like for practices, so that you're making it as the least onerous as possible for us, which is fantastic. So I think that's what we're going to be talking about, isn't it, Lucy?
Yeah, how we can fulfil those requirements on a practical level. And hopefully our members can find simple and workable ways of meeting their new obligations. So let's have a look at those obligations. So Sam, can you start us off here?
Yeah, so IPP3A says the practice needs to take reasonable steps to ensure the patient is aware of the fact that the information has been indirectly collected, the purpose of the collection, the intended recipients of the information, the name and address of the agency that is collecting the information, and the agency that holds it, if the collection is authorised or required by law, which particular law, and their rights to access it and correct it if needed.
And so the practice has got to take reasonable steps to ensure patients know that that information is being collected. So what kind of steps are we talking about? And what would be considered reasonable steps?
Yeah. So the whole thing with the Privacy Act and the Health Information Privacy Code is that a lot of it's about what is reasonable in the circumstances, taking into account the particular circumstances. When you say that list, it sounds like quite a bit of stuff that you have to let an individual know. But actually, you're already letting the individual know most of this information already in relation to direct collections within your privacy statement. And I know we'll talk a bit more about privacy statements, later on. But that's going to be a big thing about the reasonable steps is making sure that you can at least draw people's attention to it if they want to read it. We know, to be frank, people don't necessarily read the full terms and conditions at all times, but the whole thing is that they have the opportunity to do so and to understand why information is being collected. The different kind of health information you're collecting might be relevant to what reasonable steps are, particularly when you're thinking about routine collections. You know that you always receive referral letters, or that you're receiving these the blood test results through from the blood testing agencies. That kind of stuff, a really reasonable step is just to make sure that you're being really clear, when the patient signs up to the practice, even that's the kind of things that you are collecting. Also, when you are collecting this information in order to provide clinical care anyway, it's going to really naturally come up in conversation. We've received your blood results, which that we were asking for, and this is what they meant, and this is why we've got them. These are actually really common conversations that you'll already be having when you're in that therapeutic relationship to begin with. So those are the kind of reasonable steps that you can take, is just about making sure that people are aware. If it's more sensitive information, the reasonable steps might change slightly, but I think a lot of this is stuff that you can make sure that you think about ahead of time, rather than having to really have a stressful, thought and conversation every time you collect personal information. That's not what it's about. It's about front-loading as much of this as you can.
Yeah, and you also obviously have to look at the needs of the specific person, because some people may specifically want to know some specific piece of information that's being collected about them. It may be, I think in clinical practice, an STI result, that may be something that you're much more likely to actually specifically tell them, I've received this, than actually just receive it. Whereas if it's their sodium level, someone may be less concerned about their sodium level than they are about whether or not they have chlamydia.
Yes.
Yeah,
absolutely. Although that's something that you will already be thinking about as part of clinical practice. It's not like IPP3A is adding something massively new and onerous when it comes to, sharing results. If it's something that's of clinical significance that you'd already be sharing with your patient, you'll still be sharing it with the patients, just now kind of in service of IPP3A as well as the clinical relationship.
Yeah, and from the perspective of people giving advice to practices and individual clinicians about how to get ready for this, I agree with Steph that a lot of compliance with this new requirement, IPP3A, will either be already happening or come naturally, or can be achieved through making some changes to systems or privacy statements at the beginning of the relationship, rather than thinking, oh my gosh, I'm going to have to employ a new receptionist to spend all day on the phone telling people I've received information about them. And if we unpack that a little bit, for example, if you are receiving a discharge summary from the ED when your patient's gone on the weekend and been patched up after a football game, and on the face of that discharge summary it has also been copied to the patient, well, you're already in a situation where the right people know about that information flow. And if you think about clinical communications, a certain proportion of them will fall into that bucket, where the patient's part of the loop. Another proportion of clinical information you might have a practice of then immediately making available on the portal anyway, and that might be test results for those who use a portal to inform patients. So again, the patient then has good visibility to be able to log on and see, okay, well, this is information that my GP has collected about me from another source because it's been made available on the portal and I can see that. There might be another bucket of information where for whatever reason it's not already copied to the patient and perhaps it doesn't go immediately on the portal, but you can tell your patient at the beginning of your clinical relationship when they enroll, look, if you're going to be receiving care from us in order to achieve quality care and safe care, we will be receiving the following sorts of information from indirectly from other agencies or organisations about you, and you need to be aware of that. So you can front load that achieving of Rule 3A, and hopefully it will be the smallest bucket in terms of what we're asking clinicians to do differently or to do more or make more onerous, is the sort of information that might require a specific communication because it's too unusual to be covered in a privacy statement or too unusual to just say to all patients you should be expecting us to receive this from third parties. It's not already copied to them, and it's not the sort of thing you want to put on a patient portal, for example. So there will be harder cases. There always are, particularly when a rule changes and there's a new obligation and it takes a little bit of time for us to find our feet about it. I imagine that there will be doctors who are calling up their indemnifier and asking for advice, which we're all ready to give. But hopefully, and Steph can comment on this, it's not the intention of the rule change to put GP practices and other doctors in the position of spending all day proactively notifying patients when a new piece of information has been received.
Yeah, you're absolutely right. It's not meant to do that. If you come back to the heart of it, which is just about people understanding what information that you've got about them, then there are lots of ways that you can do that, and in fact you're already doing a lot of those ways already.
And how much time has the clinician or the practice got to make a notification? So say I get a letter from, I don't know, some other agency that isn't expected, and so it's not covered in my updated privacy statement. How much time have I got to tell the patient? Is it all right to wait till I next see them and say, oh, I've had a letter from wherever? Or is it something that I actually have to say, oh, I've received this now, I've got to tell the patient about it?
Yeah, so it's about letting them know kind of as soon as is practicable. But what we say in that is, if you are getting it as part of this therapeutic relationship and you're going to be talking with them about it and however long that is, a couple of weeks, however long that is, it's fine to just tell them at the point that you have them in for a consult then. So you don't need to be going ahead of time and saying, by the way, we've got this, unless you also think that it's clinically appropriate to do so. If that's something that's kind of separate from the privacy side of things you'd already be doing, that could be a good opportunity to do it.
It's often times where there are some patients we won't see very often at all, maybe not for a year. So what kind of, if you know, I don't know when I'm going to see them because they're not on any regular medications, there's nothing to bring them in, what sort of time frame would be too long? Can you I know you can't be specific. You can't say 3 months and you cut it off.
Depends what the information is probably as well. What the letter says, I suppose, and what you're doing with it.
Yeah. Can you give an example of maybe something that you'd get that you don't think would be common enough to be covered in the privacy statement, but also wouldn't, warrant having a conversation with them sooner?
Sometimes, they might have, it'll be some, like podiatrists sometimes send us things, or
Opticians.
Yeah, just
Optometrists.
things that don't really have much to do with our active treatment of patients, but they've let us know. And we would never even say, I would never even comment to a patient, "Oh, you've seen the podiatrist." It'd be like, "You've seen a podiatrist," and we don't need to mention that at all. It's those sorts of things.
Yeah, but those things, when you're talking about reasonable steps, like I was talking about before, the sensitivity is probably relevant. That's not super sensitive information. They may have already expected that the information would be shared with you, but that might be based on, their conversation with the podiatrist or not. But if you know that you do routinely receive those kind of things, then I think that's something you could absolutely put in the privacy statement. And then it might not apply to a lot of people, but then if someone says, "Oh yeah, I know that I have seen the podiatrist and I know that my GP might collect the podiatrist information," that sounds reasonable in the circumstances to me. So I'm not sure if something like that would necessarily require a full proactive notification.
Okay. So it comes down to the clinical significance and our assessment of the sensitivity of the information.
Yeah, in those circumstances, as well as what you think they probably already know.
Yeah, and it's true. Generally speaking, things that are very sensitive are things that we will be actively following up, won't we?
Yeah, and I think that's why it's hard to think of an example, isn't it? Because if you, one I was just musing over is maybe you get a letter from Age Concern that says, look, a neighbour of Mr. Jones called us and we went to visit Mr. Jones and we actually do have concerns about the situation that Mr. Jones is in because he's living with his daughter, but she doesn't seem very engaged in looking after him and he appears to be not well nourished or whatever. There's quite a lot of sensitive information in there, but it's also a situation where, because Mr. Jones is already elderly, you're probably seeing him regularly. Or if he just was remarkably robust and you didn't tend to see him that often, that's the sort of thing that would cause you to reach out and seek an appointment with that person. So often, perhaps even in the vast majority of cases, the need to inform someone that you've received information about them is going to be quite aligned with clinical acuity as well. So it's hard to think of examples where you receive information that's sensitive that someone would want to know that you now have this, but there isn't also a clinical driver to want to see them quite soon.
Yeah, so that's really helpful because it means that really it'll be very few things that we need to notify.
That we wouldn't have been ringing them about anyway.
Exactly.
You know, because obviously we get lots of information. If it's the thing we file all the time, the normal blood tests, the normal radiology, the letters where nothing needs to be done, but all those ones are probably going to be covered in our updated privacy statement.
That's right.
Yeah.
So I understand there are some exceptions where you may not need to notify the patient of an indirect collection. So should we talk about those sorts of things?
Yeah, that's a useful thing. I think the first one is about if the patient's already aware that the practice has collected that information. And obviously we've got the privacy statements. If we've updated them, the patient will be aware of what kind of information we're collecting about them, and that will probably cover quite a lot. But also I kind of think if a doctor's providing a clinical letter and to another clinician and says, I've told the patient I'm writing to you and I'll be providing you with that information, and it says that at the top of the letter, that's actually really helpful for the receiving doctor because actually that tells them, actually this patient, I don't need to notify, this patient's already been notified by the person who sent it that I'm receiving it and what I'm doing with it. And likely most of those IPP3A requirements may actually be covered off in the letter, that the patient knows what the purpose of I'm telling the GP I want you to start this medication and I want you to see them in 2 weeks, and that's all in there. And the patient then is already kind of has been given that prior warning that you're collecting it by the person who sent the letter.
Yeah, that's absolutely right. And there's also this concept of layered notification, which is that not all the notification needs to be in one place. So even if you're worried that, the letter that we've received from this referring clinician has not said the name and address of my agency as the GP practice, the indirect collector, well, that's okay because you already have that in your own privacy statement. And so if you sort of were to think about it where the information that you're being sent it is being given by this referring clinician, plus the patient has already, been made aware of your own privacy policy that says everything else that's in there, plus you already probably have something in that privacy policy to say this is the kind of information we collect for these kind of reasons. You're sort of hitting the requirements in 3 separate ways there, and I think you can be pretty confident that you've met your IPP3A obligations.
I was thinking it was one thing for hospitals actually I know when we send from all the hospitals work differently, but from my area, when we send a PEDS referral, we have to tick a box that says that the guardian is consented to us sending and understands that this information is being shared. And you can't send that referral unless you've ticked the box. It would actually be quite a useful thing on all referrals to have a thing which says, is the patient aware that this is they're being referred and who they're being referred to, and they've consented to it? That's actually quite a helpful kind of way of remembering to do it.
Yeah, I think over the longer term, when everyone's got over that initial rush of achieving compliance with 3A, and you're sort of then thinking about how you can trim the sails and improve the overall ecosystem of health information, there probably is space for either the bigger players like Health New Zealand to be saying, for example, to all specialists who are running clinics and sending things back to doctors, look, there is space for having a standard way of doing this and making sure that you copy in your patient on the face of the letter and explain, I'm sending a copy of this letter to your GP because they will require this information to continue to be able to provide continuity of care.
The GPs, invariably the letter's addressed to the GP, but CCing, I think for most or a lot of regions...
CCing the patient's really... But actually saying, I've told the patient I'm writing to you, that would be helpful.
Usually it's an opt-off system. So if you don't want the information sent, often you have to opt off that.
Yeah, I'm sure there are ways, as Adam says, we'll probably get ways of trying to make this easier for everybody as we learn from it. One of the other exceptions is actually that information that we're collecting information that's publicly available. But I don't know, can anyone think of a situation where a patient's health information may be widely available? I couldn't really think of many examples.
Only in the media.
But we're not going to be collecting health information from the media, are we? I can't really imagine.
I wonder whether it's interesting, this thing about Facebook, social media, that some social media is reasonably publicly available, although a lot of people have privacy settings on social media. But I'm wondering whether that sort of thing.
Yeah, when we were putting together the guidance on this, we struggled quite a bit. The reason that it's in there is because it, exists in IPP, 3A, so it's sort of brought it through in that way. The examples we've got in the guidance are things like if there's something in a journal article or on a public Facebook page, but it is really hard to see the situations where that information is going to be, clinically relevant and you're not also getting it from the individual themselves or something like that. So it's very possible that this will never be relied on, this particular exception.
Right. It's just there for that. And this is one of the ones that I think is more, another exception, which I think is actually worth discussing, is about if it would prejudice the interest of the individual concerned. So if notifying them that you've got it would prejudice their interests. And the example is if a patient's we're told about the collection, it will compromise their care. So I was thinking, and Steph, you can correct me if I'm wrong here. So if a pharmacist rings up a GP and says, look, I'm worried that Mr. X is not taking his meds regularly. And if the patient became aware that the pharmacist talked to the GP, that may increase their suspicion and they may not collect their medications at all. Is that the kind of thing that we're talking about? Is that where it would prejudice their care? Or is it where they'll lose trust in people? Is that the kind of prejudice we're thinking about?
Yeah, I guess the whole thing with the exceptions is that it's based on the particular circumstances in the particular case. And so it's kind of hard to give a definitive black and white answer to say, oh yeah, that will always meet that. But if you've got these kinds of situations where, if you are routinely or even sometimes receiving calls of this nature from a pharmacist, say, it may be that what you think is reasonable in the circumstances, so not talking about the exception, is actually just to include maybe something about that in your general privacy statement, rather than necessarily relying on the exception. So do you see the distinction? Saying I've actually taken
yes.
reasonable steps based on this kind of information versus I'm relying on this exception. Unless you think telling the person that they haven't collected it is actually necessary, again, for clinical care. Because that is something that you may actually be telling them. And you don't necessarily have to say, we heard it from the pharmacy. And there's no requirement in 3A to say where you've actually received the information from, just that you've received it and what it's for. But often context will make it quite clear.
Yeah.
Who else would know that I didn't collect it? Obviously the pharmacy. I don't know if that answered your question, Lucy, but...
Yeah, so you're saying you're better to put that kind of thing, if you're anticipating it, to put it in your privacy statement.
Yeah, I think if you have anticipated indirect collections, to include that in the privacy statement. This is the thing that Adam was talking about before, about the different ways of letting people know. If you have that general thing in the privacy statement, and then if it is a situation where you think it's appropriate or necessary to tell the person anyway that they're not collecting their medicine, you're actually not going to be relying on an exception. You're going to be having that conversation if you think that it's necessary. It becomes not an IPP3A thing. It's just a clinical care
I'm just thinking
issue.
about when we could use that exception then, the exception that if it would prejudice the interest of the individual.
So for other examples would be, a family member rings up and says, I think my parents starting to get dementia, they don't want me to talk about it and they're very grumpy with me, but I want to let you know, and please keep it to yourself. Those sorts of unsolicited third-party help, information. Would those? I assume those would be an exception, because that might, if you notify the patient, then they might scarper.
Yeah, and they might not be confiding in their family members about these things. Absolutely. But what would you normally do in that situation? It's not that IP3As bring up new situations. At the moment, if a family member called up and said something like that, what would you normally say? We would
probably bring them in anyway.
We would bring them in, and we would generally say we can't guarantee your anonymity if you're reporting that to us unless there's a risk of serious harm, or, because in general we don't want to be put in a position where we aren't telling the truth to our patients.
Yeah, so actually you might find that just keeping doing what you're currently doing rather than relying on this exception not to tell them is actually still the better way to approach it. That might be a relevant exception because it, might prejudice the interests of the individual if they know that you've got the information. But you might also just find it much better as part of that relationship to actually be talking to them about it, or telling them some things at least.
So one of the other exceptions is if telling the individual is not reasonably practical. And that's not necessarily about the cost, is it? I know there's another part where it says that you can't say it's not practical because it's going to cost me something to contact them. But the example is if you don't have someone's contact details and can't easily get hold of them. Is that right? So I can't imagine, for health information, we generally know if we're collecting it, we know who the individual is because they're our patient generally, and that's why we're collecting it. So I'm again thinking, can anyone think of any issues where it's not practical to tell the individual?
I wonder, sometimes, I don't know if this is even applicable, Stephanie, but, sometimes patients will tell us about a family member, what's happening in their life. And often as GPs, we just tend to put it all down. And so would that be considered we're holding somebody else's health information, but we don't have their contact details, they're not a patient.
Oh, they're not a patient of the practice. Oh, I see.
So that wouldn't be practical for us. Would that be captured here?
Yeah, it could well be. And one of the things we thought about when we were writing the guidance on this, not necessarily actually about clinicians themselves. So the definition of health agency is a bit broader than just the clinicians, and maybe one of the, the peak bodies, or when they're looking at something, they may actually receive a number of pieces of information that aren't tied to individuals. So an example that we've heard is, if you're concerned about the prescribing practice of a particular clinician, maybe there was the worry that they're prescribing testosterone more than they could, you're worried they're running a testosterone ring, then maybe what the Med Council or whoever the relevant agency is then might be doing is actually trying to find out about the prescribing history of that individual. And one way to do that, I mean, I'm no expert on how those processes work. It might be that you don't actually need any identifiable information to begin with, but if you did and you were collecting, I don't know, maybe a spreadsheet of a number of pieces of information that is health information and they are a health agency, but no way to contact the person, no actually information beyond whatever is necessary for an investigation or whatever you're looking into, then those are the kind of situations where you wouldn't expect that agency to then go and say, by the way, we've got this information, maybe unless they're calling a witness.
That's a great example, I think, because it is, the Medical Council would not infrequently ask for a doctor's prescribing history from the Ministry of Health and be given a spreadsheet in return that runs to many, many thousands of rows and potentially hundreds of patients. And it would be quite a significant task for the Medical Council to individually contact those people and let them know that they've now in possession of that one line of data on a spreadsheet.
That's right, yeah.
Very good. And so the next exception was about health information collected for the purpose of assembling a family or genetic history of an individual from that individual. So in that situation, we're sitting with a patient and they tell us, my aunt had breast cancer and she was 45 years old, and my granny had breast cancer when she was 62. So officially I've gathered the aunt's and the granny's health information, but I don't have to tell them that I've done that. Is that the situation we're talking about?
That's the situation. And this mirrors, I think it's in Rule 2 already, where one of the exceptions that says you don't need to collect information directly from an individual as if you're doing this exact thing. So you're collecting health information essentially about the auntie there from your patient. So there's already this ability in Rule 2 to collect that information indirectly. So this is just how it flows into Rule 3A. You don't need to call up the auntie and the granny, every relative of your patient to say, by the way, we've been told that you had breast cancer at age 45.
Yeah.
So that's what that is,
Right.
is for.
That sounds very sensible. So another exception is if notifying would cause a serious threat to public health or safety. What are we thinking about there? Because it's not actually that you've collected the information would cause serious risk to health or safety, it's actually that then telling the patient that you've collected the information would cause a serious risk to public health or safety. And are we thinking that if we're telling a patient that we've collected some information about them and that would cause them to go and do harm to that person who's given us the information, is that the kind of situation we're talking about?
Yeah, I think it probably is. You know this. It must mean that you know it from my neighbour. I'm going to go beat up my neighbour.
Yeah.
Depending on the nature of whatever is being shared. So those kind of things. And so, it's about if the notification would cause the issue rather than actually the collection itself that is relevant there.
Another example that we see when providing advice, which seems not infrequent in general practice, is where you are providing care to a child whose parents are separated, and whichever parent is bringing the child in for the consultant may disclose things about their former partner in the context of family violence that you would be concerned if you had an obligation to then report to the other parent who's not your patient and say, look, we just need to let you know we now have on file this piece of information that your former partner has told us about you and your lifestyle, or allegations, etc., that you have a reasonable fear would.
So if it's not in the child's best interests, for example.
Yeah, there are other exceptions that might apply too.
But this one is the exception would be that actually telling the ex-partner would be a serious risk or threat to public health and safety.
Might cause them to go around and have a go.
Yeah, okay. I think we can all understand that there are times when that exception would be used. So look, there are a number of other exceptions, and you can go and read them on the Privacy Commissioner's website, but I didn't anticipate that they'd be commonly applicable in the context of clinicians collecting health information. So I don't know, did anybody else looked at any exceptions that they thought might be relevant?
No, I guess my observation is that the exceptions are there and they're important, and there will be those rarer cases where they're engaged or you might want to seek help navigating them from your indemnifier. But the vast majority of your compliance with this new information privacy principle will be at the front end naturally.
Changing your privacy statement.
And so if you're going to invest time in preparing for this or making sure that your own practice is doing the best job that it can to be compliant, I would be putting the effort in there, particularly at this stage, rather than sweating over the exceptions, because you can do fulfill so much of your obligation around compliance if you have a good privacy statement and good systems in place around how you communicate with your patients.
So maybe that's a good point to talk about the privacy statement, because obviously every practice has a privacy statement which is given to the patient enrolment. And we've got to think about, well, what are we going to add to it to help us cover these IPP3A obligations? And the bad news is that we can't just say, we'll be collecting health information about you from various sources. That's not going to be specific enough to meet the obligations. So how specific do we need to be in our privacy statement?
The way that I would probably approach it when it comes to specificity is just to actually spend some time ahead of the obligation coming in, thinking about where the most common buckets of health information, the common purposes are that you have. You already listed some of them at the start. We regularly receive referrals, and the reason that you're collecting these things are often for a very similar purpose, which is to provide fully informed, appropriate clinical care to your patients. And so that actually makes the purpose quite easy then to be able to explain. So if you can go through and think about exactly the kind of places that you're frequently getting the information from, that will get you, I think, probably 90% of the way there when it comes to thinking about how to update your privacy statements. The other bits that are required, you probably actually already have in your privacy statements. So you need that patients have a right to access and request correction of the information. That will already be in your statement. That's already a requirement under Rule 3. There's no requirement to say exactly where you are collecting information from, just that you are collecting this kind of information for this kind of reasons. So that's why you don't have to go and say, list every specialist in your district to say we may collect from Mr. whatever for whatever purpose. It's enough to be a little bit more general than that you're getting it. You might receive specialist referrals and things like that without referring to the specific one.
And then we've actually been developing an example of a kind of a starting point for practices that look at to cover these sort of indirect corrections that we think are common. So we will be providing that for our members, but each practice will then need to look at that and then modify it to cover their own specific situation and their own processes and protocols for how they collect information.
So once the privacy statement has been updated, the best thing is for practices then to take the multi-layered approach to letting their patients know that you've updated this, and that can be, via portal message. It could be by your website, something in your waiting room, and just the usual ways that you communicate with your patients, so that you're making them or giving them the opportunity to be aware that there is this new IPP3A in place. And I understand, Stephanie, that if practices do that, make this multi-layered approach through various mediums, that is sufficient without having to ask every patient to come in and sign a consent form.
Yeah, that's right. The Health Information Privacy Code is purpose-based, and it's about telling people and making them aware of what you're doing. And if you can do that about the information that you collect, then you'll meet the 3A obligations. But if you, as part of your onboarding or your refreshing of your enrollment, if you are asking them to sign something in relation to other stuff, it could be a good opportunity to also get them to acknowledge these updates. But that's not a strict requirement. It's just something that you could think about.
But it would be a good idea that when patient practices or clinicians have updated their privacy statement, that they then email the patients or portal message them and put things on their website so that because they may not see that patient for another 2 years, you know, so actually it's hard to know.
Yeah, so different ways to let them know, but you don't need to then say, and please respond by email to let me know that you're seeing this, and that's fine. You wouldn't need to do that. So it's about taking reasonable steps to make sure that you've told them, and then it's in their court about how much they read into it once you've done it.
So, of course, there are always going to be times when the practice may receive information that isn't actually covered in their privacy code, something you hadn't anticipated. How do we deal with that? So when we're not able to rely on our privacy statement, Adam, have you got any thoughts on that?
Yeah, and look, I think we've largely covered this. If you've got something not covered by the statement, then pause and think, we will need to make the patient aware that we have this information within a reasonable period of time. And it might be, as we discussed, a situation where the information has a clinical purpose behind it, that you're going to be having that discussion with them anyway, or there's a clinical imperative to reach out to your patient. It might be a very unusual piece of information where you actually have to start thinking about the exceptions, in which case you may benefit from speaking to one of the MPS medico-legal advisors. But the baseline is, if it's not already been captured by the front-end information you did, then you do have that obligation to let them know within a reasonable period of time, unless an exception applies.
Okay, and then lastly, Sam, how will IPP3A affect how MPS and other indemnifiers handle health information which is sent to us by members when we're assisting in a complaint?
We've been spending some time, as you know, Lucy, considering this and our obligations. And so what we are doing is advising practices to add a sentence to their privacy statements, saying something along the lines of, we may at times seek advice from legal or indemnity advisors and may release relevant health information to them in order for us to be able to access appropriate advice. And what we are asking of practices is that they anonymise the information anyway before they send it in to us. And so that will hopefully cover us off in terms of receiving information, because we obviously want to comply with 3A.
So receiving anonymised information won't trigger IPP3A because you won't know who the patient is and you won't be able to...
Exactly. Yeah.
So in fact, that's probably the safest way to receive information if you don't need the patient's details.
Yeah.
Yeah, okay. So any final remarks from anyone before we close off?
Yeah, one thing I just wanted to note is that prior to IPP3A, it's been relatively free sharing of information with indemnity providers to seek that advice, and also to help the indemnity provider make decisions around assistance. It's a necessary part of the overall healthcare environment. And anonymising things before you send them to MPS can be difficult. It can take time, either clinician time or staff time. So one of the things I'm aware that MPS is exploring is whether or not there is a tool or a portal that can be used or they can make available to members to assist with that anonymisation process. Because one thing that would be good to avoid is adding friction into that advice-seeking moment, because, we don't want barriers to people picking up the phone and seeking advice from indemnifiers or other people who can actually contribute to providing good care, making the right decisions around problems they're faced with in clinical care, or responding appropriately to complaints and investigations. So I'm sure Lucy and or Sam can comment, but at least that's something that's being explored as a possibility, and if it's achievable, then that might be something that we can send news out about later.
Cool, that's a great idea.
I'm quite relieved, actually, hearing you talk, Stephanie. It's because, you look at it on the face of it initially, it's like, oh my gosh, this is just going to be so hard to comply with. But actually, it sounds like, you and your office have really thought about it, the practicalities, and trying to make it as easy as possible for clinicians to comply with. So thank you.
Yeah, thank you, Sam. And I guess that's something that mirrors what I've been seeing when I've been thinking about IPP3A, both in medical and just more generally, is that when people first hear about it, they freak out. They think this is going to grind my organisation to a halt, and it's going to be really hard and really stressful. And what we're really trying to get across is just don't panic. It will be okay. You can just think through the kind of information that you collect and then how to tell people. That's all there is to it. And it will be fine. You'll be all good.
Thanks, Steph. That's great to finish on that. So to our listeners, thank you for listening to our podcast. I hope it's been helpful. I think it's important to remember that we've been talking generalities in this podcast, but if you have a particular question about privacy, or more particularly about the implications of IPP3A to your own practice, MPS members are welcome to give us a ring on 0800 2255 677 option 3, or send us an email at advice@medicalprotection.org, and we can discuss your specific situation or question with you. So we look forward to catching up with you in our next podcast. If you like Medical Protection podcasts, please subscribe and leave a review. If you would like a podcast on a specific topic, please email nzpodcasts@medicalprotection.org.